Hello everyone, welcome to Sarva YouTube channel. Today we are ready to talk about a very interesting topic. This will be a series of discussions hopefully. And for today's discussion, I have with me Mitara Fonseca. Hi Mitara.
Hi Siddharth, pleasure to be here. Thanks for having me.
No worries, you're most welcome. So Mitara, could you just give an introduction about what we are going to talk about today?
Sure, Siddharth. So our video is going to be broken up into mainly three areas. We're going to start with just introducing you to intellectual property, what it is and how it developed. And then we're going to go over something called intellectual property harmonization. Basically how all the laws in the different countries were unified under a single standard. And then we will move on to just a very brief introduction on the different types of intellectual property rights. But I think to begin with, let's get into what intellectual property is. So Siddharth, why don't you tell us what exactly is property?
Very good. Thanks, Mitara. So basically, when we talk about property, there are a few things that we have to identify as features before we talk about intellectual property. So Mitara, now if you see all the things around us which you say you own are what? You say your phone, your laptop, your tab, your books, your whatever. All these are what in general?
Tangible things that I own.
Yes, exactly. So these tangible things fall into the category called property under law. So these tangible things can in fact be movable or immovable. We have both kinds of property. So if we consider a phone or a laptop or all these other items that we carry and use day in day out, these are tangible movable properties. All right, because you can move them from place to place. Then we also have immovable property, which is what? Lands and fixed fixtures basically, right? So you can't move a land from A to B, for example. Land will be at a particular position and it will always be there. So or a building for that matter. We still don't have technologies, I don't think, where you can move a building from one place to another, but that is what it is, not yet, right? So that is physical tangible property. All right. So then on the other hand, there is intellectual property, which we are going to talk about today. So what is intellectual property? Now, if we consider the tangible physical properties, those things or those properties we can feel, we can sense, and we can most importantly go and touch, or we can perceive them. All right. So for example, if I show you my phone, or if I show you my laptop, I will see the laptop, you will also see the same laptop. Am I correct?
Right, yeah, of course.
Yes, right. So if I show you an Apple MacBook, you won't see an Asus there. Will you? Right? Yes, you will see the same image exactly the same way. Right? But when it comes to intellectual property, it is quite different. Right? So intellectual property basically are creations of the mind, or in other terms, properties that we create using our intellectual ability or our mind. All right, so these could be anything ranging from a song to a book to an invention, something innovative that we use day in day out, or it might be a design, or it might even be a trademark or a logo, or something that we use for a business purpose. So all these are intellectual properties. So why is it called intellectual? Because it's a creation of your mind. All right. So now these properties, Mitara, tend to be quite different when we compare how people perceive them. All right. So if I talk about a book, for example, the sensation and the feelings I get when I read a book, for example, let's consider Harry Potter, the sensations and the feelings I get, would it be the same for you if you read Harry Potter?
No, definitely not. I feel like we have different nostalgia connected to the books, right?
Exactly, of course, right? You will have a different set of emotions and feelings associated with that work. But of course, the outside appearance is the same, because the book is a physical property, but intellectual property is what is inside that book, right? The actual creation, not the pages and the print, right? So of course it's the manifest, that is the manifestation, right, or the expression. So expression might be fixed onto a book, or it might be online or whatever, but at the end of the day, when you read it, when you actually consume that property, the emotions you get, the feelings you get would be quite different from person to person. All right, so the same thing goes to a song, right? If I hear a particular song and you hear the same song, the emotions and feelings that that song creates in your mind would be different. Am I making sense? Yes, right. So that is a major difference when we consider physical, tangible property and intellectual property. All right. But apart from that, apart from the fact that these emotions and feelings differ, the other features are pretty much the same, right? So just as much as you can own a phone, you can also own an intellectual property that you created from your intellectual skills. All right. So for example, if you have created a song using your own intellectual skills, you can own it. You can sell it to someone. You can rent it to someone. Just like you can rent your house, you can rent an intellectual property that you have created. There's absolutely no bar. All right. Or you can license it to someone. You can permit someone else to make use of it and give you a portion of the profits or whatever. So all these are rights which are associated with the general kinds of property that we discussed. So the same kind of rights are available for intellectual property as well. But of course, the dynamics of it would be very different. So that is why there is a separate field of law called intellectual property law.
And moving on from that, we know that laws as they develop, right, we have laws that are 100 years old, right, and that they've been amended to meet civilization as civilization evolves, right? And then you also have laws that are very new. So like you mentioned, intellectual property was one area. Like some areas of IP can be very new, and then we also have laws like the Data Protection Acts and then AI related laws. So in that effect, how has intellectual property as a law come into being? How have we come here today with intellectual property law?
Yes, Mithara, I think it's an important question, because the roots of how a law came into being tells a lot about the very nature of it, and the need the need that was there for that particular law to have come about. So even if we consider intellectual property, we can see that it's not a law that is 2,000-3,000 years old. It's very new actually if you consider the evolution of legal systems. So intellectual property laws, pretty much the modern version of it at least, came around the Industrial Revolution period, right? So it started off with the area called copyright law, which we will be talking in depth in future series of videos. So if we talk about copyright law, this copyright law became the starting point for intellectual property law, at least in the English legal system, the UK legal system, because there was a problem with regard to copying, right? So until the 1500s, 1600s, until Johannes Gutenberg invented the printer, not the modern version of the printer, but the very old version of the printer. Yes, the massive one. Yes, so until that point, the creations of the mind, which were primarily songs or books or whatever, but the amount you could spread or the amount you could reproduce was very limited, right? So for example, if you wrote a book, now in Asian societies, we know that these were written on various kinds of leaves of various trees, right? And the ability to reproduce those was limited, right? Or it was very cumbersome. So for example, there was no method where you could make 100 copies of a particular book overnight, unless so many people were working on it. The ability was very limited, and it was very costly also at that time. You had to get people to do it manually, copy one by one, get someone to write it, and then only you can distribute it.
Long process.
Exactly. But this changed with the introduction of the printing machine, right? In fact, printing machine was one of the first inventions which triggered the Industrial Revolution, right? So that is also very interesting to note. So the printing machine, what did this do? This made it possible for a person, for anyone who owned a printer, to make hundreds, 200s of copies, within a very short span of time, right? So the first book that was copied through this in a large scale was none other than the Bible, right? So that's why even to date, the Bible remains the most reproduced book in the world, right? It has been translated into so many languages and spread across the globe, basically. So how was that possible in this Industrial Revolution period? All because of the printing machine. So for books like the Bible, this wasn't an issue, right? Because no one claimed rights for the Bible, all right? So there was no problem with people distributing thousands, 2,000s of copies. There was no problem with it. But later on, what happened was, people started copying other people's works. For example, a novel, right? So you take months and months and end up with a novel. Someone else copies it, distributes it, and makes money off it. So that is when the need for rights relating to these intellectual properties was felt by the society. And based on that only, in the 1700s, the first, we call it the Statute of Anne. The first act was presented to the UK Parliament, and that was passed, right? So then only these rights were accumulated, or rights were attached to intellectual property, and this became a legal process. So that is pretty much how we started, and from there on we have progressed very rapidly in the last 200-300 years and come to where we are today, where we have a multitude of intellectual property rights as we speak.
You don't really realize how something, also an invention, but how that one single invention resulted in like a massive area of law at the end of the day, right?
Of course. I think the same is happening with AI now. I think because, yes, right. So just like the printer, now everyone is telling that this is the new industrial revolution, or the second installment of it, and that is AI. So AI is a technology like the printer, which is definitely going to transform the societies in the future.
Exactly. And it's going to be interesting to see how IP is going to really adapt to these changing technologies. So that's something for another video.
Definitely.
Okay, so we can move on to our next area, which is IP harmonization.
So when it comes to harmonization, Mitara, now I think you will talk about it. But let me first give a small introduction. I told you about the history, and I think our viewers or listeners will also want to know about what happened afterwards. So intellectual property was basically, the laws were developed primarily in the UK, but of course the requirement was felt across the globe, because at that time UK was basically controlling almost half of the countries in the world as colonies, and their works had to be protected in these other colonies also, and this was felt by the other colonizers as well. So at that point only, there was a requirement to have a common standard or a common understanding about how different countries would approach intellectual property. So then only this requirement for harmonization came, and that is how we started harmonizing or bringing these laws together, or to come up with a common understanding where countries can implement in general. So Mitara, why don't you explain how IP harmonization happened, or harmonization of IP laws happened?
Yeah, sure, of course. And like as you mentioned, that we have different IP laws that serve different purposes, right? The different IP rights have different purposes, and on top of that, the IP rights are also highly localized laws, right? They've been developed to meet the needs and the interests of the local populations, right? And I know we'll be talking about this in future videos, but as the laws developed in the various countries, they were developed in a way to grant different scopes, or provide different durations of protection, right? And then when globalization came into being, right, when globalization came into being, what happened was these or rather the variations in IP laws in the different countries, it became a barrier, right? Because with these inconsistent laws, That grew some legal uncertainties. And then when there are legal uncertainties, what happens at the end of the day for any business is that there's going to be mounting costs, and nobody wants costs for any business because that's just not sustainable, right? So that's another reason how IP harmonization became a very pressing need amongst the different nations. And so what IP harmonization essentially is where there is sort of an alignment of the various domestic IP laws, regulations amongst the different jurisdictions, so that it creates an environment where the IP rights are protected and enforced in a more consistent manner.
Yes. So why don't you talk about some of the agreements as well? At least we are not going to talk about in depth, but if you mention some of the agreements which led to this, because this was made possible, harmonization was made possible all because of the development of international law as a whole. So international law is all about treaties and agreements. So why don't you name a few agreements which made IP harmonization possible?
Of course, there are tons of agreements that have really led the way to where IP law, as it stands today, as an international, framework. But to begin with, we'll backtrack to sometime around the late 19th century with the Paris Convention. And why this law was important is because it laid a foundation for countries to offer equal protection to foreign nationals, right? And then moving forward to 1886, right, with the Berne Convention. Now, there were 181 signatories to this convention, and why this was important was because it provided automatic copyright protection to works that originated from contracting states.
Yes, correct. So all these agreements put together. So then we had the Patent Cooperation Treaty. We had
Actually,
installments. Yeah.
Following from that, the WIPO, the World Intellectual Property Organization, was created because the secretariats of the Berne Convention and the Paris Convention came together, and they created an organization called the Bureau for the Protection of IP, and that is what transformed into WIPO. Right, and WIPO is a core body when it comes to harmonization activity, because they really work towards creating these unifying standards. But then years after that, we come to a massive turning point, which is the TRIPS agreement, right?
Yes.
And the TRIPS agreement was groundbreaking for one particular reason, and that was because it was the first time a comprehensive global framework was laid down for IP protection, right? And there were 164 member states. So what all these member states signed up for was that they were made to have minimum standards when it came to developing IP laws in their countries. And on top of that, there were many things that this TRIPS agreement introduced that were very important for the development of IP law as it stands today. But another important fact was that it introduced mechanisms for dispute resolution when it comes to intellectual property issues, right? And as IP law developed over the years through these agreements, international agreements, I think it's safe to say, Siddharth, and I'm sure you'd agree with me, that IP law is one of the few areas where there is actually a very comprehensive international framework.
Exactly. I think we need to we fail to appreciate this fact even when we study intellectual property law. Because I have seen everyone coming and telling intellectual property law is scattered, it's very territorial. Yes, correct. Intellectual property law is territorial. The rights apply only within your territory. So, for example, if you have written a book in Sri Lanka, your protection is primarily limited to Sri Lanka. But it doesn't stop there thanks to all these treaties. The international framework allows you and permits you to have rights in other jurisdictions as well. Of course, there are certain requirements to fulfill, that is natural. But provided you fulfill these requirements, the intellectual property framework allows you to enforce your rights even in other jurisdictions. I think this is a significant advantage which is not there in other areas of law. Because even if we look at criminal law, for example, criminal law is highly localized, right? For example, something that is a crime in your country might not be a crime in another country. So it might be perfectly legal to go to that particular jurisdiction and do whatever you want to do. So that is how the legal world is in general. But when it comes to intellectual property, if you really want to enforce your rights, that possibility is available. So I think we need to appreciate that, and that is all because of harmonization of these laws.
Correct. Yeah. And so now, since we know what IP law is, and we know how, IP laws from different countries have sort of come to a common understanding, so to speak, why don't we get into the different types of IP rights, right? I'm sure everyone has heard words being thrown around like trademark, copyright, design rights. So we just want to give you all a very brief overview of these different types of IP rights. And why don't we start with the trademarks? Siddharth, would you like to
Yes.
explain to us a little bit about trademarks?
Yes, of course. Yes. So when it comes to trademarks, now trademarks basically talk about or refer to a source of goods, right? A trademark will protect the source of goods, right? We also call it a badge of origin. So you might have seen all these businesses, all the businesses that you associate with day in, day out, have their own branding, and along with that branding, there are different ways of expressing your brand. So it might be through a logo, it might be through a particular text, a name, right? It might be through a sound, it might be through something else altogether, it might be through an animation or a video, right? So through all these things, the brand is trying to tell you, that particular business is trying to tell you, this particular product is coming to you from this particular business. All right. So if I get an iPhone today and put the Samsung logo on it, would you think that it's an iPhone or would you think it's a Samsung?
Not a Samsung.
It's not a Samsung, correct. But that same phone, let's say I cover the camera part and I basically cover all the other branding and features and then put the Samsung logo and show you from afar, then what would you think it is? Won't you think that Samsung might have now made a phone like that? Isn't it possible? Yes, right? So that is what a trademark can do, right? Because it signifies what? The origin of the goods. So if I put the Samsung logo onto an iPhone, people will start thinking, oh wow, Samsung has started making phones which look like iPhones, right? So that is why when Huawei phones came into the market quite some time ago, people were all deceived because it looked exactly or very similar to the iPhones. Even the software was like that, right? So that feel and that the whole effect was created because of what? The trademarks that were used or the branding that was used, right? So when it comes to trademarks, basically a trademark is something, a logo. It might be a logo, it might be, like I said, a piece of music, or it might be we call it a jingle, a short chord of music, just sound clip. So it might be a name, it might be a name and a number. So all these put together, right, it denotes the source of your goods or services. So for example, if someone else starts using your logo or your name and starts selling goods emanating from another source, that is when the problem comes. So trademark law says you can't do that, right? If you have registered your mark, then you have exclusive rights to use that particular mark. No one else can use that mark. All right. So for example, Apple has obviously registered their logo, the Apple logo, which everyone is very familiar with, right? So can I, now let's say I start making mobile phones tomorrow, can I start using that Apple logo? No, because Apple has already registered that logo. I have to use something different. So as you can see, now these logos and trademarks have become so important in this globalized world. Today, the logos alone have billions of value in them.
Yes.
So that is how important it is. That is how important trademarks are. Right? The trademark alone is valued at billions, not the products. The products and the company might have a different value. That's obviously the case, right? But the trademark alone might be worth billions. So for example, another company might be willing to pay $1 billion just to purchase the rights to use that trademark, right? So that is how valuable trademarks have become. So therefore you can see, as an intellectual property, this is extremely significant in this globalized world, especially for the international commercial affairs, right? Because today a product or a service is not limited to your country, right? We all know that today products travel across the globe. Today what you manufacture in Switzerland might go to 150 plus countries, and all those 150 plus countries will identify that this is a product from Switzerland based on your trademark, right? When they see the trademark, they will know, this is a Swiss product, this is a Chinese product, this is an American product, right? Or this is an Indian product. So that so all the attributes that come with it also are a part of that trademark itself, because certain trademarks we perceive differently, right? Now the value that I might give for a particular trademark might not be the same value that you give for that mark, right? So that is why there are sometimes fanboys of certain products, right? There are cults even, right? So they prefer only that brand, right? So there might be hardcore Apple users, they buy only iPhones. They don't buy any other phone. Why? Because of the value that the trademark has created. So the overall impression that people have got because of the product, coupled with the value of the trademark, creates that very high value for each of these products. So therefore, that is a significant intellectual property kind of intellectual property that we talk about.
Very interesting. And now we've spoken about how trademarks are very important parts of, for example, a business.
Yes.
What about in the instance of confidential information? Is that also considered an intellectual property right?
Yes. So the second category that I would like to talk about is actually confidential information. So this is blended with the area of law called breach of confidence, right? So breach of confidence was not something that was part of intellectual property until recently. It was considered to be a part of areas of law like tort, but now it has become part of intellectual property, and in most jurisdictions breach of confidence is actionable under intellectual property law. So what is breach of confidence or the protection of confidential information? Now when it comes to a business might have certain trade secrets which that business wants to protect. Now if these secrets go out into the world, then the whole business would crash, right? So to give you a simple example, something that everyone knows about, now there is a saying that the Coca-Cola recipe, the exact recipe, is known only by 4 people, right? So if one of these people or their descendants or whoever let it out, then today Coca-Cola business would end, right? Because we have seen in the past so many businesses have tried to emulate Coca-Cola, but they have not been able to. They have not been able to get the exact recipe. They might get a similar taste, but it's not Coca-Cola, right? So this information, this piece of information is what makes this business continue, right? For hundreds plus years now, Coca-Cola has been there in the world. That is all thanks to this secret being kept as a secret, right? If it was known to everyone, then this business would have crashed, right? So that piece of information can be protected under the law of breach of confidence, right? So for example, if someone if you have information that someone has taken this secret and is planning to publish it somewhere, then you can immediately go to court and take some action against that person, right? So that is one kind of information that is protected under breach of confidence. So then there is another kind, the second kind, which is government information. So government information also can be protected. Now what is government information, Mitara? Now let's say you are working for a secret agency of the government, right? Or a security agency, right? Let's say an agency like the CIA, for example, right? So now when you are working with the CIA, Mitara, would you handle general day-to-day crimes, or would you be handling very high profile, very high secret operations?
Yeah,
Sort of.
very secretive operations, sensitive information.
A lot of sensitive information, right? So if the CIA were to let out those information, or if you were to let out such information, let's say you maintain a blog and you on a daily basis come and write about the operations that you're involved in, right? So then what would happen?
Yeah, that would be a major breach.
Yes, and that could cause, calamities in the society, no?
National security risk.
Exactly, right? That would be a catastrophe. So that is why under breach of confidence you can protect such information also, right? So government information, what is given to you in secrecy, the government has a right to protect it under intellectual property law, right? So that is the second kind of information that is protected under breach of confidence. Then there is another one, that is private information, right? So private information is coupled with certain human rights as well. For example, the right to maintain a private life and right to privacy, which is recognized in a lot of jurisdictions. So this is where, for example, let's say you're on a holiday, right? So I will tell an actual case, right? So the author of Harry Potter books, we all know, J.K. Rowling. So she was on a holiday, right? And she was, having some private time. So what did the paparazzis do? They went and took photos of this, and these photos were published in newspapers, right? So which caused a lot of distress to her, right? Because anyone would want to, although you might be the most famous celebrity in the world, you would want to have your private time, right? Without people peeping in and taking photos and all of that. Now that right had been breached here, because clearly these paparazzis took photos and these photos were made public, right? And the whereabouts of where she is and all of those were made public. So then she would have a right to go to court under breach of confidence law and take action, right? So that is another aspect of information which is protected under the law of breach of confidence. So you can see this is also a very vast area where a lot of different information can be protected under intellectual property law, because you have to understand why does it come under IP. Because information is also what? A creation of the mind, right? Data might be available, but you need processed. We are talking about processed information. We are talking about trade secrets. So trade secrets, you have to have a lot of intellectual ability to come up with trade secrets, right? So whoever who came up with the KFC original chicken recipe, whoever who came up with the actual Coca-Cola recipe, right? Or whoever who came up with the recipe for Cadbury chocolates, right? These are all sophisticated creations, right? They might have tried 1,000 times before finding the exact recipe which worked for them. So therefore, these are creations of the mind, and these creations of the mind can be protected under breach of confidence.
Okay, amazing. That's very useful to know, especially if there are people here who want to start a business. And these are apart from the major rights like trademark or patents and design rights or whatever, there is also these alternate routes that are still equally as important.
Yes, of course.
Yeah, and as I mentioned now, design rights, one of another very useful, very important intellectual property right. Can you explain a little bit about that as well, Siddharth?
Yes. So when it comes to designs, or we call it law of designs, so designs are a very specific kind of right given to certain kinds of creations, right? So here we are talking about industrial designs. All right. So what is an industrial design? It might be, for example, a new design of a car, right, that you're about to manufacture. So now you might agree with me. Now when the Tesla Cybertruck came about, right, everyone was enthralled by it. Some people started hating it, some people started loving it. Why? All because of that unique shape, unique design of that car. Because I have not seen a car, right, in the history of mankind which looks like the Cybertruck. So it's a very unique and a novel design. So Tesla might want to protect this. Tesla might not want Toyota creating a similar car tomorrow, right? So then that whole value, because inside the car it's the same technology, right? You don't have some new groundbreaking technology inside the Cybertruck. It's the same technology. Of course, the materials might be different, all yes. But made the Cybertruck so special was its design. So Tesla therefore would want to ensure that this design is protected, that no one else manufactures a car with a similar design, at least for a period of time, right? So then where should you look at? You should look at law of designs. So law of designs permits you to register a particular industrial design and Once you have it registered, if the registration is granted to you, then you have the exclusive rights to use that design for a particular period of time. So there again you can see this adds a significant value to any business that you are engaged in, especially if you are in the creative field, right? Because if you are, for example, an architect, or if you are working for a design firm, then day in day out this will be what you will be doing. Let's say you are an interior designer, you might come up with a unique layout for some let's say a conference room. You might come up with a layout that no one has done before, so that you can protect, right? You might be able to protect it as an industrial design. So this is what we talk about under law of designs, and that again you would see adds a lot of significant value to a business.
Now since we've spoken about already 3 types of intellectual property rights, let's move on to another major IP right, which is copyrights. Everybody's heard about it. Now, Siddharth, what if I told you I was thinking of writing a movie about this time traveler, right? And he goes back in time and he solves mysteries. And I'm thinking about this story, right? And then I go back home the next day and I actually write down a script. I have a whole fully fledged script about the entire storyline. Now I present both of these situations to you: my idea about the whole movie as well as my script. Now, which of these would actually have the copyright, Siddharth?
I would say the script, the actual script, because you're not the only one who has come up with an idea of a book which has about time travel, right? There are so many authors who have written about it.
Exactly. Yes. Like, I'm sure each of you here who's listening would probably think of multiple movies on time travel, right? But so that is exactly what copyright is. The fact that I wrote down the script, I, as the author of that script, get automatic protection over my original work the moment it is created, right? As soon as I create it, I can say, this is mine, right? And while copyright is automatic protection, now it's not only written works. You can have copyright in songs, in movies, right? In types of paintings, right, Siddharth?
Aesthetic works, am I correct?
Yes, exactly. Aesthetic works. Yes. That's the main defining type of work that can receive copyright, right? And while copyright is an automatic protection, now we spoke about the conventions before that granted automatic protection, whether it's in your country or internationally. There are some countries that provide you the opportunity to formally register your copyright, right? For example, Canada is one of those countries.
Yes.
And Siddharth, is there anything else that you think I should add for what copyright is?
No, I think you covered everything. Just that I think you made that distinction about ideas and expressions. So we would like to reiterate to our listeners that copyright does not protect ideas, right? Because if that were the case, we would have had only one book in the whole world which talked about a magical world, right? And that would have been some book written thousands of years ago, and that would have been the only book, right? We wouldn't have had Harry Potter, Narnia, Lord of the Rings, all these books coexisting together, because all these books talk about virtual worlds or alternate universes. Yeah, right. It might be Alice in Wonderland, right? Yes.
Exactly. Yes. And this idea, expression, dichotomy is something that's very often spoken of in copyright, and it's something that we'll, of course, get into in like a more in-depth extent in some of our later videos. But in essence, in a nutshell, that is copyright, right? Exactly. And the next and the final intellectual property right that we want to introduce to you would be patents, right? Now, patents is something we hear often thrown around in media in general, right? And one of my favorite shows, which is Shark Tank, has the word thrown out ever so often. And for those who don't know what Shark Tank is, it's a TV series where inventors or business owners come forward, put forward their products and service, and they get these massive business tycoons to invest in their products. And the moment someone comes forward and says that they have a patent for their product, or they have a patent pending for their product, the investors are almost instantly more interested or instantly more willing to invest in these products.
Why is that, Mitara? Why is that the case? What?
That is a good question.
What value does a patent? Yes.
Exactly. The value that a patent would bring in this case is that it provides the patent holder a monopoly over the product, in the sense that they're able to manufacture, they're able to use, sell, distribute that product for a certain time period, and that is usually 20 years, right? So that
could be different from
country to country, but typically it's 20 years, right?
Yes.
And so this is a very exclusive right that's given to the inventor, and in exchange for getting this monopoly, or rather the monopolistic right to use their invention, you have also a contribution to public knowledge, where you provide the information or the know-how of how this invention was created to the public knowledge base, right?
Yes.
And there are different types of patents. You have patents for products, patents for processes. You have a patent for a product that a product by process, in this case where a certain type of product is created using a particular type of process. So for example, if you take clothing manufacturing, right? If you have a certain type of dye that is produced through a certain type of process, that whole from the process to the product, that can all be considered under a certain type of patent. And we have, patents are not only for very fancy gadgets like, fancy mouses or whatever. It can be for something as simple as a toy. For example, Lego. Lego has a very popular patent, and, there are ancillary gadgets. So I know that I'm not a Lego fiend myself. I don't know if you are, Siddharth, but there is like a... Okay. So there is a gadget where you can pull apart the Legos, which... also has a patent protection. Anything from phones to maybe type of glass, patents are a very essential component, especially if you are an inventor, someone who is looking to create something. And like Siddharth mentioned, for other IP rights, it's also something that has a very high value.
Yes. And also, Mitara, to add to that, I think now in today's world, so many countries have also started considering patent protection, even for certain aspects which were originally protected by copyright. So for example, if we consider computer software, there are countries which have recognized patent protection for software. So different unique kinds of software now, especially because the AI revolution is now coming, we would see a lot of new innovations which come about in the field of software. So based on the jurisdiction, you might be able to apply for a patent, and who knows, you might be able to get it, right? And if you can get a patent for your software, that's a big deal, right? It might mean that your software is worth $1 million, for example, because only you can then copy that software, because software is something that can be easily copied, right? It is something someone can simply take the code, because it's a known fact, right, that if all these big companies put out software on a daily basis, but they are the copy of those software, or we call it we might call it different names are used for these products, but we might call it the cracked versions are available the day after, right? So that means all these crackers, they are working on it day in day out to copy this software, right? So if you don't have any kind of, now I'm not saying that patent law will allow you or permit you to stop all crackers, that's not the point, but if you don't have any kind of protection, then anyone can legitimately do it, right? So because your only protection would be then copyright protection, but patents would allow you to have a high level of exclusivity for your product, especially if it's something like a software, and you will be able to make millions of that patent. right? So another very famous field where patents are used a lot is the field of medicine, right? So medicine manufacturing, that's a massive industry where patents are thrown in, on a very frequent basis, and there are whole legal teams working in the top tier, medicine manufacturing companies, and their sole job is to ensure that the medicines that they manufacture are protected by patents, right? Because if you create a groundbreaking medicine today and you get a patent for it, then for 20 years no one else can come up with that medicine, right? And that could be billions of dollars within 20 years.
Yeah, moving, not only like when you consider, when you think of patents, you're always thinking of, oh, like how you think of it in the context of, say, a private entity, right? But even when you take national policy, patents are very important because governments invest not thousands, billions of dollars in research and development, right? And so the natural output of that, you would want it to be income generated from owning patents. And so there's a whole different, with brain drain and, the immigration of various patents, basically. There's a whole other discourse on that, and another topic that you should look forward to in upcoming videos.
Also, Mitara, now we have talked about 5 areas of intellectual property laws. Just to recap, we have talked about copyright, we have talked about patents, then we have talked about trademarks, designs, and finally breach of confidence or confidential information. Now, to give an overview to all our listeners, copyright protects aesthetic works, any work that has some perception on you, an emotional sort of perception which creates an aesthetic effect on you, right? So that is what copyright protects. Then if we look at patents protect what? Inventions. So that's why we talked about medicines or all these other aspects which will bring you money or profits when you sell these as products. So patents therefore protect inventions. Trademarks protect the source of goods, and we have given so many examples for that. Designs, of course, protect industrial designs. And finally, breach of confidence protects 3 kinds of information which we talked about: government information, private information, and trade secrets. So these are the mainly recognized intellectual property rights which are available to all of you in general. You have to understand that intellectual property does not have any limits, right? You can be an inventor even if you're 5 years of age. You can be an inventor even if you're 95 years of age. There is absolutely no limit, and you can do a business at any age. There is there is nothing saying you have to have a particular qualification to have a trademark. No, nothing like that. So these rights are as good as, I would say, any other human right that we all have, right? So just like human rights are common to all humans, intellectual property rights also are common to anyone. As far as you have created a creation from using your intellect, you are entitled to these rights. Of course, you have to understand that some rights you get only once you register them with some authority, right? Some rights are automatic. So, for example, copyright is automatic. The moment you create the work, you get it. But patents, trademarks, designs primarily are registered rights. You will get your rights once you are granted the registration, right? And then breach of confidence, if we see, it's again generally automatic, right? So these are the dynamics which we wanted to talk about in today's video. We hope that you have all got a comprehensive understanding of what intellectual property is. We will be going into these aspects in detail in future videos. And if you have any questions, please drop them in the comments section below. If you have any feedback regarding these videos as well, please feel free to comment. And if you're happy with this video, if you think your friends also should see it, please like and share the video, and also subscribe to our channel. We would be bringing you more videos of this nature in the future. So Mitara, would you like to say anything else?
No, I think you covered it all, and hope to see you all in our next video.
Of course. So thanks Mitara once again for joining, and thanks to all of you for listening to us. or watching us on YouTube, and see you again. Thank you.